Good morning. This is Professor Russell Jones. We're going to cover this morning a couple searches and seizures that are called administrative for special needs searches. If you remember in camera was the beginning of what was considered a special need or an inventory search. In camera, they were doing these administrative searches of homes based upon the statute that the city had. And the court held that because of the special need for that particular search, that is the governmental interest, the heightened governmental interest versus the privacy right of the individual, that search would be permissible on something less than traditional probable cause. And they instituted this balancing test that was based upon the reasonableness provision in the Fourth Amendment. That is, no person shall be subjected to unreasonable searches and seizures. Uh, and it was done, these searches and seizures were done according to some administrative procedures that were set up by the city. And this was passed on to Terry, if you remember, because Terry was something less than probable cause for an arrest when a person was stopped. They said, look, we're going to look back at camera. We're going to look at what camera did. Camera said that we can have a stop. We can have a search on something that's less than traditional probable cause. And the intrusion has to be limited. And that's what we had in Terry. The intrusion was limited. It was for a limited purpose. And there was a governmental interest in Terry, that is, crime prevention and crime detection. And this is passed on to other inventory of special needs searches. And the first inventory search, and we're going to talk also about special needs seizures. You're going to get an extra here. Special needs seizures, that's going to be roadblocks and also border stops. Um, the first special needs search that we're going to talk about is going to be the inventory search. That is the automobile inventory. Now, I say it's automobile inventory, but it also includes inventory of other personal belongings that a person may be taken from a person at the time of booking, and that the officers actually place them aside and they inventory them before they place them aside. Now, the first case that talks about, or the first important case, very important case that deals with the special needs to inventory automobiles was South Dakota versus Opperman. In South Dakota versus Opperman, it says, an inventory is a special needs search. That is, the government has a special need for the purposes of engaging in this type of activity. That is, inventorying your property. It is not a search for criminal activity or contraband. That, if you remember from camera, that was one of the biggest things in camera. This was not a search for criminal activity or contraband. Now, uh, it may lead to criminal activity. It may lead to contraband that will subsequently uh, involve a criminal prosecution. But the purpose of the search is not for criminal activity or contraband. Hence, it is not based upon probable cause. Going back to camera, because it is not for criminal activity, because it's not for the search of contraband. It will not be based upon probable cause. It is conducted to standard police procedures, which help to guarantee that the intrusions is limited to the scope necessary to carry out the special caretaking function. There has to be standard procedures for the purposes of engaging in these special need or inventory searches. And the purpose of them, and it goes on and says, the three legitimate state interests support the inventory search. Three legitimate state interests, and this is why we allow these inventory searches of the car, inventory searches of a book bag or luggage or something that this person might have on them at the time of the arrest, and they take it into the station, and then they want to search it or they want to go through it. Because an inventory search, again, like plain view, it's not truly a search because of the three caretaking functions that they have outlined or they have defined for the purpose of the inventory search or the special needs search. Three legitimate state interests support the inventory search. Protection of the police department from false property claims. The police office department is protected from false property claims. Persons and possessions are taken. Persons say, hold it, I have X, Y, and Z, and these things are missing. But if we do an inventory, an immediate inventory after we arrest a person, we do an immediate inventory after we bring the automobile in, and then we can protect them from the false claims, from false property claims. Protection of property interests of the owner. That is, a property interest of the owner. We want to make certain that the owner's property is protected, the owner's property is preserved. So when the owner is eventually released, if he's released, then his property will be intact. And third, Protection of the police and public from dangerous weapon, always public safety. If you remember, public safety is always a part of something that we do, and when they are talking about the Fourth Amendment. And so this public safety, there might be something there that might be dangerous to the police officers, might be something there which might be dangerous to the public. Therefore, we want to discover it. We want to discover it before it causes injury. Police discretion must be controlled when conducting an inventory. There must be some control on the discretion of the police officers. Again, that's why you have to have standard procedures. The inventory is based upon standard procedures of the police department, the precinct under where the inventory search is going to take place. The search of the bag has to have standard procedures as far as the search of the bag. And so there are standard procedures that control the discretion. We don't want them under these special needs searches to conduct fishing expeditions, just as when we talk about a warrant. We don't want them going in and conducting fishing expedition, just doing a broad search, and it ends up becoming a search for criminal activity or contraband. This is a special needs search, and it must meet one of these three requirements or criteria that has been set for this inventory search. The government must show that the officer was operating pursuant to standard operation procedures promulgated by the department. The government must show that the officer was operating pursuant to standard operating procedures promulgated by the police department. We go on and we look at Illinois versus Lafayette. We've seen in Opperman that you can inventory. You can inventory a person's car. You can inventory the car if there are standard procedures, and the officers follow those standard procedures. And it's for one of those three criteria. It's for one of those three criteria that is set up. There is a need. There is a need for that inventory search to protect the person's property, to protect the integrity of the police department, and also for public safety. And therefore, you don't need probable cause. And you really don't need reasonable suspicion. You do not need reasonable suspicion for an inventory search, because all we're doing is inventorying the property for the purposes of one of those three criteria. And therefore, that's why I say it's not truly a search. Let's go on to Lafayette versus Illinois. In Lafayette versus Illinois, the question became, well, can they inventory a shoulder bag? There was a shoulder bag inside of the automobile. And can they inventory the shoulder bag? The court said it does not matter that the preservation of the property could have been attained in a less intrusive manner. Even if a less intrusive manner existed of protecting some particular type of property, it would be unreasonable to expect police officers in everyday course of business to make fine and subtle distinctions in deciding which containers or items may be searched and which must be sealed as a unit. And therefore, the court said that, hold it, we are not going to draw a line as far as items within the car. We're going to allow them as long as they search within the policies that are established by the police department, by that particular department. We're not going to place them in a situation where they have to make a decision, with decisions on the spot as to, can I search this or can I search that? But Colorado versus Bertin defined that principle just a little bit more, or refined it or defined it just a little bit more. Colorado versus Bertin says police can inventory containers. Remember, shoulder bag is a container based upon New York versus Belton. Anything that can hold something else is a container. And so the Colorado versus Bertin says police can inventory containers within the vehicle. So if there's something within the car, the police can inventory it. Officers may exercise discretion within the bounds of established criteria. And so the criteria under which the inventory search takes place, they must give them that particular discretion in order to search the containers. And so you look at the criteria. The criteria says that containers or searching of containers, are permissible. And thus, the officer can also search the containers within the car, which may include the shoulder bag, which may include a box with something in it. Officers may exercise discretion within the bounds of established criteria on the basis of something other than suspicion of criminal activity. Remember, we're not looking for contraband. We're not looking for criminal activity. We just want to preserve the property. And lastly, the last case, important case that deals with automobile inventory, dealt with whether they could search a locked suitcase. There's a heightened expectation of privacy in that suitcase because it carries our private belongings. because it carries with it some indicia or some degree of privacy that we would like for the government to respect as far as our luggage, as far as our personal belongings. Uh, and they went on to say, and for the verses Wells, the opening of a locked suitcase is not justified as an inventory search where there is no established policy. Again, for there to be opening of a suitcase, for there to be opening of a piece of luggage, there has to be established policy. We don't want the police officers going on a fishing expedition. We don't want them to have unfettered discretion, and therefore we want them to follow policy. If we say that's a government need, explain that need. Show me why we need to search, and show me why we need to search these other things. And so the policy has to be established. And as long as they act within that governmental policy that's established by the department, then it's going to be fine. The opening of a suitcase is not justified as an inventory search where there is no established policy whatever concerning the opening of closed containers. The Fourth Amendment does allow the officer some latitude to decide whether the container may be opened in an inventory search. This discretion can be pursuant to department regulations in light of the nature of the search and characteristics of the container itself, pursuant to department regulations. And he has some discretion, but there has to be some department regulations. And they have some discretions. And it's based upon the characteristics of the container and the nature of the search. Does it go overboard? What does the container look like? And therefore, he will have the right to conduct the search. Louisiana, and I want to give you just a kind of basic little touch upon what Louisiana says in reference to, no, that's not, that's the roadblock or the suspicion of seizures. Now, I want to move on before we move to standing. Give me a couple of minutes to look at roadblocks because they're really interesting. Roadblocks themselves are suspicionless seizures. Roadblocks are Terry seizures. All of these cases that we're talking about are truly derivatives of Terry. They come from the reasonable suspicion standard that was set in Terry because they are limited intrusions for a special purpose. And you have to act within the confines of that special purpose of this particular intrusion. And so we talk roadblocks or suspicionless seizures. It has said that a special need, and roadblocks are a special need intrusion. And so what do we need if it's going to be a special need intrusion? It cannot be for criminal activity. It cannot be for criminal activity. And there must be a special governmental need. Let's look at what Michigan versus Sis says. A special need beyond criminal law enforcement is not required to support reasonable balances or stop at a fixed checkpoint. And so it says for a stop at a fixed checkpoint, you don't even need a special need. You don't need reasonableness. You don't need reasonableness. The court relied on the Terry line of cases rather than a special need line of cases. They said that a roadblock is a Terry case. It's not a special need case. In a special need case, the inventory case, special need case, camera administrative case, it's a special need case. You have to show some special governmental need. Balancing of the state interest. And Terry was based upon balancing. So it is not a special need. I think I said earlier that a special need, it is not a special need case. It's based solely on Terry. Terry is based upon the balancing of the governmental interest against that intrusion upon the person's privacy. And the governmental interest outweighs the intrusion upon the public person's privacy, then it's going to be permissible. And in Terry, that intrusion, the purpose of intrusion was crime prevention and crime detection. And because of the limit intrusion that the person is engaged in, the government is engaged in, they said in Terry that, the governmental interest is going to exceed that right of privacy because it's a limited intrusion for a special purpose. And here we have the same thing when we talk about roadblocks or suspicionless seizures. Against the limited intrusion, the court balanced the state's heavy interest in eradicating drunken driving. The Chief Justice rejected the argument that sobriety checkpoints did not effectively advance the undeniable state interest. And so the state interest in roadblocks, what are the state interests? State interests to protect the highway. It's public safety. The state has an interest in public safety. They want to make certain that you are licensed to drive. They want to make certain that your car has been checked and that your car is safe to be on the highway. They have inspections and they have proper inspections. They want to make certain that you're not drunk. It's all for public safety. and that the criteria that's necessary for the stop, the seizure, or at roadblock is to be reasonable. The criteria is that it must be reasonable. And if it's going to be reasonable, this is what is set up on. This determines reasonableness. These are the criteria. The seizures are not arbitrary, but are controlled by proper procedures. Again, just as your special needs searches, just as administrative searches, there has to be proper procedures that are established by the department. Officers are not given unfettered discretion to set guidelines for the stop. There are some standard criteria set. They're not given unfettered discretion. They're going to stop every car. They're going to stop every other car. They're going to stop every third car. They're going to stop every fourth car. They're going to conduct certain things. They're going to be asking certain questions. The procedures are set. The officers are not getting discretion. And officers have to work within the guidelines of those procedures which are set by the department. Again, because it's based upon reasonableness, it's based upon the special interest that the government has in protecting our highways and protecting our roadways. The intrusion of the checkpoint is limited. The intrusion of the checkpoint is limited. That means that the government can ask you to move to the side if they develop some reasonable suspicion. They can ask you to move over to the side, to pull over, and then engage a little further. But it has to be limited. It has to be limited for the purpose for which the intrusion is established: public safety, roadway safety. And so it's limited. It's limited, and so they're going to check this, they're going to check that. Now, in checking these things, reasonable suspicion may arise. Remember, in all of these cases, even though they are not for the purpose of criminal activity, that they can eventually lead to criminal activity if the government discover criminal activity in carrying out these procedures. And with the roadblock, the same thing. The SITS permits a seizure, but not a search for law enforcement purposes without probable cause. The court has allowed searches on less than probable cause in 2 cases, in Terry and in camera. And so the SITS seizures permits a seizure. It does not permit a search. It only permits a seizure. And interesting enough, if you look at it, that seizure is for a particular governmental purpose and is not for a criminal purpose. Therefore, a seizure or an interdiction, a checkpoint interdiction that's based upon the search for drugs is not permissible. It is not a permissible seizure under the Terry the Terry analysis, I should say. Excuse me. It is not a permissible seizure under Terry analysis. In Indiana versus Edmond, they conducted a drug and addiction checkpoint. And the question became, could they conduct a drug and addiction checkpoint? Listen at what the court said. We have never approved a checkpoint program where the primary purpose was to detect evidence of ordinary criminal wrongdoing. It cannot be for ordinary criminal wrongdoing. And drug detection is for what? To determine drugs that is criminal wrongdoing. Each of the checkpoint programs that we have approved was designed primarily to serve purposes closely related to the problems of policing the border or the necessity of ensuring roadway safety. Because the primary purpose of the Indianapolis narcotic checkpoint program is to uncover evidence of ordinary criminal wrongdoing, the program contravenes the Fourth Amendment. It contravenes the Fourth Amendment. There are circumstances that may justify law enforcement checkpoints where the primary purpose would otherwise, but for some emergency, relate to ordinary crime control. For example, the Fourth Amendment would almost certainly permit an appropriate tailored roadblock set up to thwart an imminent terrorist attack or to catch a dangerous criminal who might flee by way of a particular route. And so there are exceptions to the fact that you can't set up a roadblock for something other than a governmental interest, that is public safety. That if you have a terrorist attack, if a person is fleeing, and this is a most reasonable route that the person would take, you can set it up, and then that's looking for criminal activity. But those are the 2 exceptions that Illinois versus Edmond says. Now, really interesting. One last case dealing with that, and then we're going to go on to Stding. Last case dealing with that was Illinois versus Lister. Very interesting. There was a 70-year-old man was killed by motorists. He was on his bicycle one night. He was riding his bicycle. And that's me, people. I'm going to be riding my bicycle. Don't y'all run over me. But he was riding his bicycle one evening, and he was struck by a motorist, and the motorist fled the scene. The motorist fled the scene. And so what the police officers did, about a week later, after the night, and at about the same place that the accident occurred, they set up a checkpoint. The officers set up a checkpoint. They set up a checkpoint for questioning people about the particular accident. Uh, but the respondent, he drove toward the checkpoint. He swerved, nearly hit one of the officers. Alcohol was detected, and he was arrested. Now, the checkpoint was for the purposes of gathering information about the crime that was committed a week before. Respondent or defendant drove to it. He was drunk. He tried to get away. He swerved off. He hit a police officer. They tested him. He was drunk. They arrested him for drunk driving. He says, "Hold it. This checkpoint was for the purpose of criminal activity. Therefore, it's not a proper checkpoint. It does not meet the requirement of Edmond versus Illinois. I'm sorry, Illinois versus Edmond." The court said the checkpoint stop here differs significantly from that in Edmond. The stop's primary law enforcement purpose was not to determine whether a vehicle's occupant was committing a crime, but to ask vehicle occupants as members of the public for help in providing information about a crime, in all likelihood committed by others. And so it was not a stop for the purposes of gathering information for the commission of a crime or looking for a crime. It was a past crime, and they wanted information about the past crime, and therefore it was not a criminal checkpoint. The police expected information elicited to help them apprehend not the vehicle's occupants, but other individuals. Therefore, it was not a criminal checkpoint. Very interesting case. Very interesting case. Uh, Now, let's move on to standing. If you look at standing, the standing, I'm going to do this in about 3 minutes. Standing on the federal level is based upon CATS, and the person has standing to file a motion to suppress evidence that's illegally seized if he can show that he has a legitimate expectation of privacy in that particular thing. If he has that was seized, that thing that was searched, if he has a legitimately expectation of privacy under CATS, that society is willing to uh, respect a legitimate expectation of privacy. Uh, Louisiana, and that's basically what it says. Recognize that there is a legitimate expectation of privacy. If the person has a legitimate expectation of privacy and the things seized or the things searched, then he will have standing. Let me give you an example. For instance, if I'm walking down the street, let's say I'm walking down the street with Miss Milo. And Miss Milo, I'm sorry that I hope this doesn't offend you, but we're walking down the street and I have my drugs in my pocket. Police officers know that I do drugs, and so they want to stop me. And so what I do is that when I see the police officers, I hand my drugs to Milo, and Milo sticks them in a purse. Well, I stick them in Milo's purse. I take my drugs and I stick them in Milo's purse. Now, police officers notice what I do, and they take Milo's purse and they search it. They search it. They don't know what I place in the purse. They don't know why Milo and I are walking down the street, but they search Milo's purse. They don't have probable cause. They don't have reasonable suspicion. Now I said, hold it. This is a tainted search. This is the fruit of a poisonous tree. Therefore, it should be suppressed. The courts are going to say no. The court's going to say no. Why? I don't have a reasonable expectation of privacy in Milo's purse. I must have a reasonable expectation of privacy in the thing that was searched. And Milo is the one who has the right to file a motion to suppress here. But Milo has not been criminally charged. Jones has been criminally charged for evidence that was found in Milo's purse. And thus, I don't have a reasonable expectation of privacy in Milo's purse. If I abandon something, I don't have a reasonable expectation of privacy. I've given this to a third party, and court has said case and case after case, that I do not have a reasonable expectation of privacy. And so the standing definition of the standing finding under federal rules is based upon the rule from CATS. The person must have a reasonable expectation of privacy and the thing searched or the thing seized. Louisiana is different. Louisiana, Article 1, Section 5 of the Louisiana Constitution says, any person adversely affected by search or seizures conducted in violation of this section shall have standing to raise its illegality in the appropriate court. And so if I'm adversely affected, That is, if you're going to see something, you're going to search somewhere, and then I am adversely affected, then I have the right to sue. I have the right to raise the motion to it, the motion to suppress that evidence, because it's found in violation of Louisiana Constitution. It's found in violation of federal law. That I have the right to bring it, and so I am adversely affected when they seize Milo's purse. They seize Milo's purse, and I am adversely affected. Therefore, in Louisiana, I can raise. I have standing to raise, or standing to file the motion to suppress and argue that motion to suppress. Now it becomes really interesting. Let's assume that Milo has lost her purse. Milo has lost her purse, and she's reported the purse loss. Reported the purse loss, and she's given up on the purse. And then what happens is that police officers come, and I see the purse on the ground. I take it, I stuff things in it. I stuff my drugs in it, and I kind of toss it back on the ground where I saw it. And then the police picks the purse up, and they search the purse, and what do they find? They find Milo. They find my drugs. Now, under Louisiana law, I said, look, I'm adversely affected. I'm adversely affected because you're going to use the drugs in order to prosecute me criminally, and therefore you found the drugs violation of a privacy right, and I have a right to raise the motion to express. They're going to say, no, you don't. No, you don't. You know why? Because no one's rights have been affected. The purse was abandoned. The purse was lost. Milo has given up hopes of finding this particular purse. Therefore, nobody's rights were offended. And thus, you do not have standing to bring it because nobody's rights was offended. It was not your purse. It was not your purse. It was an abandoned purse. And someone's rights have to be offended. If Milo has it and her rights were offended, then I can bring it. But if no one's rights were offended under Louisiana law, then I do not have standing to bring that particular, the particular motion to suppress. That's my presentation for this morning. Truly enjoyed it. Hope you all take a look at this. It's going to be on the final examination. It's going to be something on the final examination about it. So take a look at it, and we will see you on this evening. Thank you so very much. Goodbye.